Welcome everybody to our webinar this Saturday morning, bright and early. We're going to cover disparate impact, what it is and why it should matter to every tenant and housing provider. My name is Steve Tomkowiak. I'm the Executive Director of the Fair Housing Center, Metropolitan Detroit. And joining me is Ingela Bertolini and Aaron Hagos. We all work together at the Fair Housing Center. What they're going to do is they'll field questions in that, please, and then pass them on, share comments and things like that. Do not have to wait to the end to ask questions in that. You can, put your questions in anytime. The training is for you, so feel free to speak up at any time. Here's the rules. The ground rules for it is, first of all, this webinar is being recorded. Again, we'll stay afterwards. At the end of the webinar, I'll turn the recording off and you can ask questions that maybe require more details or something that, or maybe not necessarily on topic, but real important. So you'll have that opportunity as well. Make sure you put your questions into the Q&A and not the chat. At the end, I will ask you to put some comments and things into the chat, but if you have a question, please put it into the Q&A. And of course, a disclaimer, this webinar is just general information. We're not giving specific legal advice. If you have those kinds of questions, you can reach out to our office and we can answer them that way or put you in contact with attorneys that will answer those questions. For a closer look video of this webinar, and it's going to have the PowerPoint as well, will be posted on our website at fairhousingdetroit.org under services and resources, and video of other webinars and conferences are also available on our website. And a big thank you to Michigan State Housing Development Authority, MSHDA, for sponsoring this webinar. They made it possible. So thanks, hats off to MSHDA for supporting fair housing and inclusiveness in communities. So here's what we're gonna do. We're gonna take a good close look at the rapidly changing law as to disparate impact claims in fair housing cases. And then we're going to look at following situations. I'm going to just go through these real briefly and we'll answer them at the end of the webinar. Housing providers' policy is to reject applications from prospective tenants with a record of domestic violence on their screening report. Does that create a fair housing problem? Here's another one. The CrimSafe criminal record screening product provides a one-page report indicating whether an applicant has disqualifying records or criminal records. The report also includes arrests that do not result in a conviction and has a look-back period of 99 years for convictions and 7 years for non-convictions. Does that raise a fair housing issue? Another example, tenants are a married couple. They live in a one-bedroom unit. They have a new baby. The bedroom is at least 150 square feet. The apartment complex gave the tenants 6 months to move to a two-bedroom unit or vacate the apartment due to a two-person per bedroom unit policy. In another case, a mobile home park required all the occupants to demonstrate their legal status in the country by presenting an original Social Security card or original passport, visa, or arrival departure form. And the park will not renew the lease and immediately move to evict any tenant with one or more occupants who do not provide the required documentation. In another case, insurance brokers would not insure properties if Section 8 voucher residents or voucher recipients lived in the building. And in another situation, the city rezoned property from RM to residential townhouse or RT, defining townhouse as a single family dwelling unit. In that case, the developer wanted to build multifamily dwelling and that was blocked. In another situation, lender policy doesn't extend, lender doesn't make loans available for single family homes for less than $60,000. In other words, that's a minimum loan amount of $60,000. And the last situation, a realtor firm offers 3 tiers or levels of service based on the list price of homes. And so we're going to look at those at the end after we go through and do a kind of a deep dive into disparate impact. And the objective is to be able to identify potential fair housing violations in such situation, understanding how disparate impact theory of liability helps to address it. So here's a history of disparate impact under the Fair Housing Act. Congress debated Fair Housing Act from 1966 to 1968. It started off as fair housing, but then got into debates about whether, anti-rioting or urban unrest, that kind of a thing. So it really stagnated. In March of 1968, the Kerner Commission report came out. America's moving toward two societies, one black, one white, separate and unequal. So that got fair housing back on the front burner for Congress. As it was moving, Dr. King was assassinated on April 4th, 1968. And while the funeral that was going on, and there was certainly urban unrest over that, Congress passed the Fair Housing Act on April 11th, 1968. President Johnson signed the Fair Housing Act into law. The goal of fair housing, as Supreme Court noted, eradicating housing discrimination is a policy Congress considered to be of the highest priority. What that has to do with disparate impact? Because disparate impact helps achieve those goals, or it should help achieve those goals. So it is directly tied to disparate impact, has a close relation with the objective and goals of the Fair Housing Act. And so disparate impact, kind of a checkered history. It got adopted into Title VII. The Supreme Court approved it in Griggs' case in 1971. And then in 2005, in the Smith case, the Supreme Court recognized disparate impact theory of liability and age discrimination in employment. However, from 1968, the passage of the Fair Housing Act until 2012, there was no Supreme Court decision under the Fair Housing Act approving disparate impact as a theory of liability. Nonetheless, HUD and the federal courts of appeals had all recognized disparate impact as a theory of liability. In February 2013, there were several attempts to bring the issue of disparate impact before the Supreme Court. During that time, HUD in February 2013 promulgated a disparate impact final rule. We're going to refer to it as HUD's 2013 disparate impact regulation. And then in June 2015, Supreme Court finally heard a case, and in Texas Department of Community Affairs versus Inclusive Communities Project, we'll just call it ICP, Inclusive Communities Project, approved disparate impact as a theory of liability under the Fair Housing Act. That occurred in June 2015. But the developments went on much beyond that. The Michigan Fair Housing Laws, Persons with Disabilities Civil Rights Act, and Elliott Larson Civil Rights Act were passed in 1976. And in 1984, disparate impact was recognized under the Elliott Larson Civil Rights Act. And there's, I don't think, any dispute that it also will be applied under Persons with Disabilities Civil Rights Act. However, disparate impact has not been raised in housing cases under either Persons with Disabilities Civil Rights Act or the Elliott Larson Civil Rights Act. There's a rare exception in the Michigan Civil Rights Commission opinion and final order, MDCR versus Countryside Town Homes. In that case, a disparate impact claim was dismissed. But other than that, I searched the appellate decisions by the Michigan Supreme Court, Michigan Court of Appeals, found no disparate impact cases in housing at all. So it's just not being used. Maybe there's a lack of awareness or whatever, but certainly it's an important theory. It needs to be considered. All right, so let's go further. What is discrimination? Discrimination is, it's unlawful discrimination. We use the term discriminate or discriminating, but really we mean unlawful discrimination. It's adverse treatment or adverse impact against one or more protected classes. It starts with a protected class member who receives adverse or unfair treatment in comparison to others due to their protected class status. What are protected class statuses? The Fair Housing Act has 7: race, color, national origin, religion, sex, familial status, and disability. The Rehabilitation Act, if there's federal financial assistance, that also covers claims based on disability. The ADA as well. Under Michigan, Elliott Larson Civil Rights Act and Persons with Disabilities Civil Rights Act have the same 7 categories as the Fair Housing Act. Plus, it will also have age and marital status. Age and marital status is not covered under federal law. It is covered under state law. And I can list the ones for Michigan. There's 9 under Elliott Larson: religion, race, color, national origin, age, sex, familial status, or marital status. And the person with disability, Civil Rights Act has disability, of course. So there's really, those are the, those are the protected class categories under Michigan. Now, there's also very important civil rights or fair housing law that would apply to fair housing situation is the Civil Rights Act of 1866 and 70. Those are codified at 42 United States Code sections 1981 and 1982. Section 1982 is actually the bedrock fair housing law. It doesn't have any exemptions or anything like that. It applies. It often will have even a broader or longer statute of limitations period than the Fair Housing Act. And it covers race, color, ancestry, and alien status. Doesn't necessarily, Supreme Court said it doesn't cover national origin. However, when it comes to the Civil Rights Acts of 1866 and 70, or we typically call it sections 1981 and 1982, does not recognize disparate impact claims, only intentional discrimination claims. So the main fair housing laws when it comes to disparate impact cases would be the Fair Housing Act, the Rehabilitation Act, the ADA, and of course, Michigan's Elliott Larson Civil Rights Act and Persons with Disabilities Civil Rights Act. So what are, there also are local ordinances. Here's a few of them listed here. Detroit has 11, Inkster has 9, Taylor has 8, Livonia 6, and so forth. If you see in the bottom, Clinton Township, it says receives complaints for violations of, this is in their ordinance, receives complaints for violations of federal and state fair housing laws and provides for referrals to the Michigan Department of Civil Rights and our Office of Fair Housing Center, Metropolitan Detroit. Even if there is no local ordinance, or local ordinance may have the categories that you see here, it doesn't mean that the federal and state protected classes apply. They certainly do apply. Typically, then at the local ordinance level, they'll give additional protections. For example, there's a growing number of cities that are now adopting source of income as a protected class. So they'll typically can give additional rights, but they cannot take away from rights that exist at the state and federal level. So all of the federal and state protected classes still apply. When it comes to local ordinance, it's just not clear if disparate impact claims may be raised under local ordinance. We just don't know. There's no information on that. I should clarify too, if you see, for example, in Detroit, it covers sexual orientation, gender identity, and so forth. The interpretation of sex under Title VII, under Fair Housing Act, is by court decision. You can assume, and it has been several decisions, it does cover sex discrimination, includes discrimination based on sexual orientation, gender identity, transgender status. Though some of the local ordinances will spell that out expressly, it's still going to be covered even if it's not mentioned in the statute. And notice too, in Detroit, it says at the bottom, or gender identity or expression of that person's friends, cohabitants, or associates. If you're associated with someone who has protected class status and you receive adverse treatment because of it, you still would be covered. For example, a parent who's being evicted because they have children, really discrimination is focused against the children, but it results in the disruption of the parents' housing, they're covered. If you have a relative, father, mother, spouse, something who has a disability and they receive adverse treatment because of the disability and it affects you. For example, I had a case where they were issuing fines. The person needed a assigned handicap parking space. They wouldn't provide it. It would park in a standard parking space, handicap parking space, and they kept issuing fines, $50, $100. And his spouse was affected because the fine was issued against both of them. So that would be his claim as well. So if you're associated with someone with a protected class, you are covered as well. So here's just, so disparate impact claims require an adverse impact or adverse effect against one or more protected class members. So let's go through a couple examples. How about smokers? Smokers are not a protected class. discrimination against smokers is not unlawful. In fact, many housing providers adopt no smoking policies. HUD even recommends it. Families with children is a protected class. Discrimination against families with children is unlawful. Attorneys are not a protected class. Discrimination against attorneys is not unlawful. Some may think, well, attorneys are going to sue everybody if we rent to them. No, that may be true, but they're not a protected class. Civil rights protections only kick in when you're talking about a protected class. Other ones, source of income, or include Section 8 and other places, it would include FHA loans, VA loans, veteran status, students, etc. It's not covered under federal, those categories in Michigan are not covered under federal or state law, but so some of those categories are adopted. For example, in college towns, like in Michigan State, they have student status, matriculation status as a protected class. Some cities have source of income, veteran status. If it's covered as a protected class in the city or community, then it would be unlawful discrimination. If it's not listed as a protected class, they may be discriminated against, but it's not unlawful discrimination. So here, again, I can't say enough about it. There is no discrimination case. There is no housing discrimination case unless there's a protected class that's being affected. So here's the two theories when it comes to discrimination. There's disparate treatment, which is the most often alleged, and disparate impact, which is not often alleged. Disparate treatment requires proof, direct or indirect, proof of discriminatory intent against one or more members based on their protected class. Now, the intent can be direct, like a smoking gun type evidence. Sometimes people, say that, but more often it's inferred circumstantial evidence, and it can be inferred from the fact that similarly situated persons comparing the protected treatment of the protected class members with non-protected class members. If there's differences in treatment, intent can be inferred. Disparate impact is less often alleged. It requires proof that a facially neutral policy or practice has a disproportionate adverse effect or impact on protected class members. Typically, it's shown through statistics, but there is no requirement to show discriminatory intent. We'll come back to that in a second. So here's a lot of development that's been going on under disparate impact, theory of liability under the Fair Housing Act. Like I said, in February 2013, HUD promulgated its disparate impact regulation. In June 2015, short time later, the ICP decision approved disparate impact theory under the Fair Housing Act. In October 2016, HUD issued guidance notice applying the Fair Housing Act's discriminatory effect standards to insurance. But then in September 2020, HUD came up with a new disparate impact regulation, making disparate impact claims much more difficult to both plead and prove. Pleading means before the case could even get off the ground in court, it required such specific pleading requirements, also had very stringent proof requirements. I'm not going to go into the 2020 rule, but it was highly challenged. There was a court case filed, 3 court cases. The first one filed Massachusetts Fair Housing Center versus HUD. Preliminary injunction was issued stopping implementation of the 2020 rule. HUD didn't appeal and challenge it. Instead, HUD withdrew or didn't go further with the 2020 disparate impact regulation. And then in June 25th, 2001, HUD proposed to reinstate the 2013 disparate impact final rule. So it kind of goes back to the 2013 disparate impact regulation. It's a proposed regulation. So it's still not settled. This area is still not settled. HUD hasn't done a final rule when it comes to the 2013 disparate impact rule. But right now, it is treated as being in effect. And so what we have here, there's what the state of disparate impact is now. It's an interplay between HUD's 2013 disparate impact rule and the Supreme Court's decision in ICP. It's the interplay between those two that determine the current standard for disparate impact liability. Well, let's go through HUD's rule, and then we'll go through the Supreme Court's decision, and then look at then how courts have responded to that. And then we're going to go through our examples. There's a three-part burden shifting analysis that HUD has in their 2013 rule. The plaintiff, first one is call it the prima facie case. Plaintiff has a burden of showing that a facially neutral policy or practice either actually or predictably results in disparate impact on a group of persons, or creates, increases, reinforces, or perpetuates segregated housing patterns because of race, color, religion, sex, handicap, familial status, or national origin. People that come into fair housing with an employment background sometimes are really unaware that fair housing laws and standards do not match up with employment. There is no perpetuation of segregation component to disparate impact in employment. There is one when it comes to housing. So that's the first element. It's showing that there typically statistics showing a disparate impact or effect on a protected group of persons, and then either at the challenge practice, it creates, increases, reinforces, or perpetuates segregated housing. You see how important disparate impact is. It gets directly at the problem of segregation. There aren't any other laws that really do that directly. Indirectly, affirmatively furthering fair housing does that. Would be the only other example that I would think of that really kind of hits at the problem of segregation. So if the prima facie case is met, then the defendant has the burden to show a legally sufficient justification for the challenge practice. And it must be necessary to achieve one or more substantial, legitimate, non-discriminatory interests of the defendant. And it must be supported by evidence. It can't be purely hypothetical or speculative. It can't be something they make up. They have to have a specific reason why they want that policy in place. If they do and have a legally sufficient justification, then the third part, the plaintiff has a burden to show another practice that has a less discriminatory effect that achieves legitimate interests served by the policy. In other words, the plaintiff could say, the defendant could have come up with another policy that achieved those interests without the same type of or a less discriminatory impact or effect. So that's where it stood. So when the Supreme Court ruled in 2015, the Supreme Court had before it HUD's 2013 disparate impact rule. First off, Supreme Court recognized disparate impact theory of liability under the Fair Housing Act, and it cited and appeared to agree with HUD's 2013 disparate impact rule on the three-part burden of proof analysis. And it did recognize, like HUD did, that actions leading to the perpetuation of segregation can give rise to disparate impact liability. And then it listed examples of housing practices that can give rise to disparate impact liability. And here's the examples they give. Unlawful practices include zoning laws and other housing restrictions that function to exclude minorities from certain neighborhoods without any sufficient justification. The Supreme Court said those type of claims reside at the heartland of disparate impact liability. And also, this was Justice Kennedy in ICP, noted that disparate impact liability permits plaintiffs to counteract unconscious prejudices and disguise animus that escape easy classification as disparate treatment. In this way, disparate impact liability may prevent segregated housing patterns that might otherwise result from covert and illegal stereotyping. I was doing a presentation yesterday, and a gentleman in the class said, well, it seems to me when they do disparate impact violations, well, they know what they're doing. They know people are being excluded. And he's right. Sometimes it looks like it's a facially neutral policy, but they may really know what will happen by that policy, but they're not going to come up with a discriminatory policy on its face. They're not going to readily share it, but it still may be underlying why that policy was adopted. And that's, it's a good sound reason why the Supreme Court recognized disparate impact liability, because some people don't reveal their motives. They will cover it up in what sounds like a neutral policy, but in effect, they really are seeking to exclude protected class members from housing or housing related needs like loans and insurance, that type of a thing. But the Supreme Court went a step further they came up with certain safeguards, and their concern was to prevent government, private entities from using numerical quotas. There could be no quota system. In other words, have to have so many minorities or so many protected class members. They don't want quota systems. Quota systems raise constitutional questions. They also came up with three other things. First, a causal connection. Supreme Court made a stringent causal connection, that there has to be a causal connection between the policy and the discriminatory effects. And it warned that a causal connection won't be established if there's only a one-time decision rather than an overall policy. It's not likely to be met as a causal connection if many different factors entered into the challenge policy, or federal law limits a defendant's discretion in fashioning a policy. In other words, if the defendant is just doing what the federal law requires it to do, it's hard to say that there's a causal connection between the policy they're implementing and disparate impact liability. They also have a robust causality requirement to ensure that racial imbalance does not, without more proof or more evidence, establish a prima facie case of disparate impact. And it's Supreme Court articulated it to protect defendants from being liable for racial disparities they did not create. And then it also was, Supreme Court cautioned that disparate impact is intended to remove artificial, arbitrary, and unnecessary barriers. There's no disparate impact liability unless the policy creates artificial, arbitrary, and unnecessary barriers. The difficulty is it's hard to understand exactly, for example, robust causality, determining how that's met. And there were criticism of this. First off, when the appeal came before the Supreme Court, the appeal was filed for two questions. First, are disparate impact claims recognizable under the Fair Housing Act? And the second question, if they are recognizable, what are the standards of burden of proof that should apply? Well, the Supreme Court only granted review as to the first question. Are disparate impact claims recognizable under the Fair Housing Act? The Supreme Court did not grant review to determine what the standards and burdens of proof are that should apply. Yet the court did exactly that, then went into the second question in the ICP decision. Very unusual. Based on that, it wasn't briefed, and I don't believe the ICP decision is really clear as to what is sufficient causal connection, robust causality, and artificial unnecessary barriers. It's hard to say. So could argue that that language is dicta, right? Because it wasn't necessary to the Supreme Court's decision, but that hasn't stopped courts from really looking at those quote unquote safeguards that the Supreme Court articulated in determining whether disparate impact liability has been established. Housing industry is, again, using ICP to critique HUD's use of the 2013 disparate impact regulation, saying that, well, it shouldn't really be the standard because of what the Supreme Court said in its 2015 decision in the ICP. And so HUD in June 2021, as I mentioned, issued a proposed rule to reinstate the 2013 disparate impact rule. It's a final rule. It hasn't been finalized and promulgated. So housing industry groups argue that returning to the 2013 regulation wouldn't conform to the Supreme Court standards, guidelines, and ICP. According to the housing industry groups, the HUD's 2013 disparate impact regulation lacks robust causality, doesn't require a direct link between the disparate impact and the alleged injury. And that was, they're referencing Bank of America Corp versus City of Miami. That's a fair housing case. And it says it does not recognize practical business considerations such as a profit motive as a valid business objective. The profit motive in that were those kinds of points were contained in HUD's withdrawn 2020 disparate impact regulation. Virtually all housing policies are done with a profit motive. That would, if you take the 2020 disparate impact regulation, it makes disparate impact claims almost impossible to be established. There are no such barriers when it comes to disparate impact in employment. There shouldn't be one in housing. And HUD's 2020 disparate impact regulation went well beyond what the Supreme Court issued in terms of cautionary standards and ICP. So here it's coming back to it again. Let's get real practical. So what exactly is the standard? Well, lower federal courts are kind of doing an interplay between HUD's 2020 disparate impact rule and the Supreme Court's ICP decision. As best I can determine, this is sort of the approach that they're using. First, the first step, there's a 3-step burden shifting framework. The Supreme Court seemed to adopt it, so I think I'm pretty comfortable that we have a 3-part burden shifting framework. In the first step, plaintiff must sufficiently allege at the pleading stage or establish at summary judgment or trial a robust causality requirement, and requires the plaintiff to specifically identify the policy or policies causing a disparity. One-time decision will not be viewed as sufficient. Evidence only showing a pre-existing statistical disparities between protected and non-protected groups is not sufficient either. It must show that the policy resulted in some greater disparate impact or effect than otherwise just exists. And again, the disparity also must not have been caused by factors separate and distinct from the challenge policy. And the next part is the robust causality requirement. Again, this is still on the first element. And courts are split. Some find robust causality established if a plaintiff presents statistical evidence showing that a protected class is disproportionately affected by a challenge policy. Other courts are more stringent. They require a plaintiff to show not only that the challenge policy had a disproportionate adverse effect or impact on a protected class, but that the challenge policy caused the statistical disparity. So this requires proof as to the adverse effect a policy has in creating or exacerbating residential segregation in a specific area or region. The problem I have with this latter one is it seems to have been drawn from the segregative effect claims and should not be imposed as a proof standard for all of disparate impact claims. So that's a challenge. Robust causality, understanding that as a challenge. On the second step, courts agree defendant has the burden of showing that the challenge policy is necessary to achieve one or more substantial, legitimate, non-discriminatory interest. This is not a high standard, not a high one for a defendant to meet. Not every defendant meets it, but it shouldn't be a high standard. And then there could be federal law or other regulatory requirements may limit a defendant's discretion in fashioning a policy. That needs to be considered. On the other hand, policies that create artificial, arbitrary, and unnecessary barriers will give rise to disparate impact liability. Under the third step, ICP and HUD agreed, the Supreme Court and ICP agreed with HUD that the burden of showing defendant's interest could be served by an alternative practice with less discriminatory impact or effect. That burden is on the plaintiff to prove that. That's a change from some federal court decisions which put defendant having the burden of proving the absence of any alternative practices or policies that would serve its interest with less discriminatory impact. So with that in mind, all right, let's go through the nuts and bolts of it. Let's look at some post-ICP disparate impact claims in various housing contexts. You can see the list here: domestic violence, use of criminal records, occupancy limits, citizenship status, insurance policy, zoning. Then we're going to look at a couple minimum loan and minimum list price policies and see how those can give rise to disparate impact violations in fair housing cases. And the first one, domestic violence. And again, the reason to go through these is because people are not recognizing violations when they occur. We're just not getting the complaints. And in Michigan in particular, there's just an absence of disparate impact claims in housing. So some of the courts will go through all 3 steps. Sometimes they just examine the first or first and second. So it varies with the individual case, how far the case went along. For example, if the facially neutral policy or practice or statistical evidence is insufficient, the case will end at the first step. Maybe on the second step, the respondent fails to, or defendant fails to come up with a justification. Well, the case will end at that point, defendant loses. If defendant establishes, then it's the third point, whether the plaintiff can establish alternative practice. If the plaintiff can't, then the defendant wins because it has satisfied step 2 and the plaintiff can't meet step 3. So in this one, domestic violence housing provider has a policy to reject applications from prospective tenants with a record of domestic violence on their screening report. The policy is facially neutral. It applies to men and women alike. And so to establish the first step, there should be some kind of statistical evidence of disparate impact or effect. And statistics show that nearly 3 in 10 or 28.8% of women and 9.9% of men have experienced rape, physical violence, and or stalking by an intimate partner during their lifetime. I came up with the stats on that. There's other stats as well. This is just for an example. You may want to drill down within your community for those statistics. This is at the national level. But regardless of what's used, women are statistically more likely to be a victim of domestic violence rather than a perpetrator. Okay, this will meet the first step. The facially neutral policy or practice. It says it's going to, exclude people with a record of domestic violence. Doesn't say whether they're men or women. But statistics show that women are statistically more likely to be a victim. So the next step is to the housing provider, what are the legitimate interests? The legitimate interests raised would be safety concerns. Housing provider did not want incidents of violence or other problems associated with domestic violence at its complex. This could be challenged because women who are domestic violence victims are not likely to engage in domestic violence or give rise to safety concerns. So arguably, step 2 is met, only arguably. So let's look at step 3. Are there alternative practices? Well, there are. Very simply, the housing provider could make an individualized determination as to whether an applicant was the perpetrator or victim of domestic violence. If, majority of women were victims of domestic violence, they could be allowed to rent. And with the men, the same thing, individualized determination as to the men. That would meet the safety concerns, yet it would eliminate the discriminatory impact or effect. So that type of a policy to exclude applicants with a record of domestic violence would be successfully challenged as a violation of disparate impact under disparate impact theory of liability. And again, the reason I'm bringing and doing this conference is this. People, when they go look for housing, they run into these policies and they don't recognize that often. They won't recognize that these are actually discriminatory. Here's another example, use of criminal records. And this Connecticut Fair Housing Center versus CoreLogic decision. And the case challenged defendant's CrimSafe criminal record screening product. So the CrimSafe would give the housing provider a form listing type of crimes for which housing provider like CrimSafe to screen. Using these various categories, the defendant provided criminal record screening services on a one-page report indicating whether or not disqualifying records were found. And the housing provider would then take the up or down decision by CrimSafe, and that would be the decision. Well, what they found is the report included arrests that did not lead to conviction. It also had a maximum look-back period of 99 years for convictions and 7 years for non-conviction. So it really went back into the history. And it provided no additional information such as the underlying records, the nature of the crime, the day of the offense, the outcome of it, nothing. And so statistically, well, before you go to that, plaintiff background, he was Latino. He suffered injuries in a car accident. He's unable to speak, walk, or care for himself. The year before, he's arrested for retail fraud, but he wasn't convicted. And they used the defendant using the CrimSafe report, informed the housing provider that he was disqualified based on some unspecified criminal records. There really weren't any. So here's the statistical proof. Black Americans in the US were more than 4 times as likely as whites, and Latinos 2.5 more times likely as whites who have been incarcerated or jailed at some point in their lives. At the state level, incarceration rates for Black Americans were twice the national rate. For Latinos, over 3 times the national rate. In 2015, 169 in 100,000 white adults were incarcerated in jails. The rate went up to 174 and 100,000 for Latino adults, and a whopping 607 and 100,000 Black Americans were incarcerated in jails. So there is a disparate impact, and the use of the CrimSafe reports would result in disparate impact against Black and Latino applicants. Then what legitimate interests are served? Defendant claimed that they were screening for arrests and convictions. They said that it adequately characterized risk levels. It reduced bias. However, the court looked at it and said, well, the defendant didn't provide any real sound legal or statistical empirical support for treating a pending arrest as sufficient to determine whether the prospective tenant would pose a threat to the health or safety of the community, residential community. And court also relied on HUD's 2016 guidance, informal guidance, treating arrest records alone as insufficient to warrant denial of admission. So the next part is are there alternative practices to satisfy legitimate interest with a lesser or a discriminatory impact or effect? The court found that plaintiffs met their burden under ICP and HUD's 2013 regulation, showing less discriminatory practices. And the plaintiffs came up with three alternatives. First, they recommended excluding arrests that did not result in a conviction from being used in a CrimSafe decision. Second, adopting an empirically based limit on the look back period for convictions. Why is it reasonable to go back 99 years on convictions and 7 years on arrests? Because statistically, after so many years, and really not very many years, 2, 3, 4, 5 years, and someone doesn't pick up another case, they become very rapidly no more likely than the general public to pick up another case. But here they did not use any kind of empirically based system to determine whether someone was legitimately going to be a threat from a criminal conduct standpoint. And so that wasn't sufficient. So there was an alternative approach that could have been done to eliminate the disparities to permit more Black, Hispanic applicants to be approved for rental. And then the third one, sharing the underlying criminal history information with the housing provider without making a leasing decision so that the housing provider can perform an individualized assessment as to an applicant's criminal history. All criminal records are not the same. There are some that are a threat and there are some that are not. Here in Michigan, if someone writes a bad check uttering and publishing, it's a 14-year offense. That's different than someone being on a sex offender list, registered sex offender. It's different than assault with intent to do, bodily harm or assault with intent to murder, something like that. They need to distinguish. For example, what kind of rehabilitation has the person then, started working or gotten a degree and reestablished their life. So anyways, all three were pretty sound reasons of alternative practices that meets legitimate interest, safety, while eliminating the disparate impact or effect. There was a case out in New York, I think it was 900 plus housing apartment complex. And again, they were liable under disparate impact, the way that they use criminal records. And the settlement in that case was over $1 million. So these cases can be very, very significant. Another example of disparate impact in housing are occupancy limits and this Rhode Island Commission for Human Rights versus GRAW. This impacts familial status discrimination. And we shared this one earlier. Tenants were a married couple. They lived in a 1-bedroom unit and they had a new child. Their bedroom measured at least 150 square feet. The apartment complex gave them 6 months to move to a 2-bedroom unit or vacate the apartment due to a 2-person per bedroom unit policy. A flat 2-person per bedroom unit policy. Because of the child, they now had 3 people. And so therefore, they said they either have to leave the unit or go to a 2-bedroom unit. Now, is there evidence? Statistical evidence. Policy had a statistically significant impact on families with children in comparison to families with children. Families with children tend to be what? Larger in size. So what happened is disparity ratios of 4.55 for a 3-person households with children meaning that policy would affect, disparity would affect 4.55 times more likely to affect families with children as opposed to families without children. It was disparity ratio of 14.25 for 4-person households and 6.92 for 5-person households. Even after controlling by income range, income levels, disparity ratio for 3-person households was 3.9, well above the 1.25 ratio of statistical significance. And legitimate interest, the apartment complex argued they complied with the view of local official regarding local building code, thinking that there was 150 square foot minimum square foot requirement to permit occupancy by 3 persons. The way it works is in the same standard in Grau applies to many situations in Michigan. If there is a no local building code which has minimum square foot requirements for a bedroom, you have to default back to the International Property Maintenance Code. The standard we see here on the screen is the International Property Maintenance Code. It says that it has to be 170 square feet for the first occupant and then 50 square feet for each additional occupant. So what the apartment complex did was they took 70 plus 50 plus 50, and they thought that was 170 square feet. It would require 170 or more square feet in order to accommodate 3 people in a bedroom unit. That was wrong. And the court correctly noted that the 70 square feet only applies to the first occupants. If there's more than one occupant, in other words, if it's less than 70 square feet, it can't count as a bedroom. But if it's at least 70 square feet or more, it counts as a bedroom unit. Then the requirement is 50 square feet per person. So 150 square foot bedroom unit could hold 3 persons. If it's 150 square feet or more, it can hold 3 persons, regardless of the age. If, for example, you're talking about an infant, you could even say, how much space does an infant use? So even if it's 130 square feet, you could even make the argument that a mother, father, and a baby could fit in a 130 square foot unit. But 150 or more square feet meets the needs of 3 adults. Now, there are some, for example, Ann Arbor has a slightly different formulation. In Ann Arbor, it says that it requires 50 square feet per person in a bedroom unit, but only need to have 40 square feet for children 12 and under. So in Ann Arbor, all they would need would be 140 square feet would be sufficient to house mother, father, and child, or even mother, father, or baby. So the court said they were wrong because the complex failed to establish legitimate interest on the second step. The court didn't reach the third step. The housing provider lost as a matter of law. So there's no need to consider alternative practice with less discriminatory effects. Occupancy is a real, the net effect of it is with disparate impact, it opens up housing for persons with disability. Families with children. It could also do disability, it could do it for everybody, but it makes housing available. So is that a burden? Not really. When we have complaints come in, we just, either the complainant does it, or we'll do it, we'll measure it, or we'll do a FOIA request for blueprints in that to determine the size of the bedroom units. Citizenship is another, it's going to be a big topic moving forward. This is the Ray's case from the 4th Circuit. And here, a mobile home park began enforcing a previously unenforced policy, required occupants to demonstrate their legal status in the US. You can see what they're asking for: original Social Security card, passport, or other type of documentation. And the policy was that they wouldn't renew the lease and seek eviction for any tenant with 1 or more occupants. They would seek the eviction for any tenant with 1 or more occupants who didn't provide the required documentation. Previously, they only enforced that rule as to the specific tenant on the lease, but starting in mid-2015, they began enforcing it against all occupants over the age of 18. For tenants who don't comply, the park gave them 21 days to cure it or 30 days to move out. They also came up with additional fee for each month a non-complying tenant remained in the unit. And in mid-2016, the fee increased to $300 per month. So where is the statistical evidence? The evidence showed Latinos comprise 64.6% of the undocumented population in Virginia and were 10 times more likely than non-Latinos to be adversely affected by the policy. And undocumented migrants were 36.4% of Latino population and compared to just 3.6% of the non-Latino population. So the court ruling as to step one, they didn't merely allege that Latinos face higher evictions than non-Latinos. Rather, they felt the court believed that it met the robust causality requirement under ICP, showing that the policy disproportionately subject Latinos to eviction in comparison to non-Latinos. So right there, I mean, the court did not get into this second and third step, but this shows evidence that the first step was met. And the case then proceeded. So citizenship status. And again, I believe this occurs probably elsewhere and people are not recognizing this as a possible disparate impact violation. Another example would be insurance policies, National Fair Housing Alliance versus Travelers Indemnity Company. National Fair Housing Alliance had their testers posing as purchasers of a 4-unit apartment complex. They called various insurance companies. They informed the insurance companies that they were participating in Section 8 Housing Choice Voucher Program. In each instance, the testers were informed by the insurance brokers that the insurance companies would not insure properties if voucher recipients resided in the building. And so the statistical evidence of this disparate impact or effect is that households in the DC are approximately 45.2% non-Hispanic, Black, or African-American, and 41% non-Hispanic white, with approximately 47.1% of the households headed by women. That's the overall statistics, but when they drill down to those receiving vouchers, 92% are non-Hispanic, Black, or African-American, in comparison to only 45.2% of the entire DC population. Only 1% of non-Hispanic whites receive vouchers, though non-Hispanic whites comprise 41% of the entire DC population. When it comes to percentage of households receiving vouchers that are headed by women, it was 81.5% compared to the overall percentage of 47.1% of households headed by women in the entire DC population. And then when it comes to residents participating in the voucher program, we're really concentrated in 4 main census tracts that were 84.7% Black or African-American compared to the entire DC percentage of 51.1%. So to exclude them from getting insurance would end up what? Not having housing available to predominantly Black or Hispanic, primarily Black or women-headed households. So that's race and sex discrimination. The court ruled on step 1, satisfied the ICP robust pleading requirement, and the court found the insurer's policy will exacerbate racial and sex-based disparities, having a disproportionate impact on African-American residents and members of women-headed households in DC. Here's another one, the zoning. I'm not sure how to pronounce it, Mahaney Management versus County of Nassau. So what happened is they wanted to build a multifamily dwelling unit, and due to public pressure, the city rezoned the property from RM, like multifamily, to residential townhouse or RT, and it defined townhouse as a single family dwelling unit. So that just blocked them from multifamily. It was a affluent community, and they really didn't want multifamily units in that community. Statistical evidence, minorities were just 4.1% of the city's overall population, only 2.6% of the population living in households. Further, the city contained no affordable housing. It's just stunning. No affordable housing at all. And one opportunity to provide it, the city blocked it. The original multifamily residential group of RM zoning would have allowed plaintiff to construct up to 311 residential apartment units on the subject building site. So what happens is they blocked it. There would be no multifamily residential dwellings. The 311 unit residential apartment unit would be completely blocked because of the city's policy. And so what happened? The court found the city zoning policy restriction on the development of multifamily housing would perpetuate segregation in the city. Good case. The city contained no affordable housing and they blocked it. That sure sounds like perpetuation of segregation. So what was the legitimate interest? The city said, well, reduce the rezoning, basically to block the project, would advance legitimate interest by reducing traffic and the strain on the public schools, right? And the court then looked at the HUD's 2013 DI regulation, and it said that it changed the burden of proof on established absence of a less discriminatory alternative. So anyways, it accepted step 2. What the city said, fine. They're claiming reducing traffic and strain on public schools. That's fine. They accepted it. Not saying they agreed with it, but the defendant, the city, articulated legitimate interest. So the third step is, were there alternative practices? So the first thing the Second Circuit said is it abrogated the earlier Second Circuit rule required the defendant, the city, to show that there are no alternative practices. Under HUD's 2020 disparate impact regulation, it's up to the plaintiff to show that there are alternative practices that could be adopted with a lesser discriminatory impact or effect. And they found, because the district court placed the burden on the city rather than the plaintiff to establish the absence of less discriminatory alternatives, the court reversed and remanded the case to the district court for a ruling on the third step. I wish they would have addressed the third step. It would have been interesting to see how that got analyzed. My gut feeling is reducing traffic and the strain on public schools. I don't know. So there's a little bit of it in the decision. You just ask you for 311 units. Certainly it will lead to more students in the public schools. I don't know. They probably get an increase in state funding. So what's the concern for the city? Reducing traffic. I'm sure there's things that can be done to manage the traffic aspect. So my gut feeling is plaintiffs are going to win in this case. I sure hope they do. But I think it's just great to see how disparate impact, like I said, really gets at the heart of perpetuation of segregation. Great legal theory. Couple examples. Minimum loan requirements as to race could involve to race and national origin discrimination. A lender's policy not to extend loans for single family residents of less than 60,000. In other words, if you apply for a loan less than 60,000, you will be turned down because there's a minimum loan amount requirement. And the minimum loan amount statistically shown to disproportionately exclude potential minority applicants, low-income communities, because their income levels are the value of houses in which they live. The lender will be required to justify the business necessity for the policy. Another example, this is a pending case our office and others are involved in. This is a minimum list price for realtor services involving race or national origin discrimination. In the first step, realtor firm offers 3 tiers or levels of service based on the list price of homes. They either do no service. The second one, they're not, they will refer it to a non-partner, to a partner agent or partner realty. It's a non-employee of the firm. And the third level would be the best available service with a commission discount. Now, the various levels of service vary nationwide. In some areas, for example, there's no service at all. If the property is going to be listing for less than 100,000, it'll be referred out between 100 to 200,000, and the best available service will be homes that have a list price of 200,000 or above with a commission discount. When these get, the statistical evidence shows this is for Detroit community. There's other statistics I could add in. 2,635 homes were located within extremely non-white zip codes. Of those homes, 187 or 7.10% were offered best available service. 9,802 homes were located within extremely white zip codes. Of those homes, 5,438 or 55.48% were offered the best available service. You can see how best available service certainly correlates very strongly with the percentage of homes either in white or non-white communities. And the plaintiffs then calculate a disparity ratio dividing the percentage of best available service homes in extremely white zip codes by the percentage of best available service homes in extremely non-white zip codes. Disparity ratio is 7.82%. Buyers and sellers of homes in extremely, I shouldn't say percent, disparity ratio 7.82. Buyers and sellers of homes in extremely white zip codes were 7.82 times more likely to be offered best available service than buyers and sellers of homes in extremely non-white zip codes. Disparity is statistically significant to a 99.99 confidence rate, less than 1 in 10,000 chance that the disparity occurred randomly. Even more compelling is a mapping tool showing what this policy did. The bottom part, the gold, is where they just don't service the area based on the limited number of agents that they have. But when you get to northern part of Wayne County, including Detroit, and you get into Macomb County and Pontiac, you can see what areas are being excluded because of that minimum list price policy. It's excluding almost all of Detroit. To the far right or far east would be the Grosse Pointe areas. They get service. Some areas downtown Detroit get service, maybe Palmer Park, Midtown, but that's pretty much it. And then western, northwest Wayne County gets full service with the commission. Pontiac doesn't, Mount Clemens doesn't. You can see the racial disparity is clear. This looks just like a redlining map because it is. And looking at Detroit, you can see even further with Detroit. Look at the difference here. You see how that policy ends up redlining. Anytime service is based on the price of a loan being offered, or service is limited based on the amount of a loan sought, or based on the list price of a home, you run into these kinds of disparities. That is statistical significance. So what do you do if you suspect a violation? First thing, always gather evidence, text messages, emails, letters, other communications. And what records you don't have, ask for copies of them. You know, if something was said to you orally, send a text message. Hey, I need you to explain again, and get them to put it down in writing what occurred. The next thing is report it. Our office is available. We have a phone, 313-579-FAIR. You can report suspected violations there. You can send an email, info@fairhousingdetroit.org, or as many do, go to our website, fairhousingdetroit.org, and submit an online complaint. You can even upload documents. It's very user-friendly. HUD has a phone number and two phone numbers and an online complaint form that you can use. The Michigan Department of Civil Rights, like our office, has a phone number to receive complaints. You can email complaints to the Michigan Department of Civil Rights, or you can complete an online complaint form. Wait, but I hope what we've gone through today kind of gives you some awareness of what disparate impact, how important it is, how useful it is. And I'll say this, it's very, very important from the standpoint of a housing provider, and it's very important from the standpoint of individual consumers and tenants, home purchasers, right? It's clear, first off, disparate impact theory of liability is now well established as a recognizable, cognizable theory of liability in fair housing cases. And not only do disparate impact claims allow someone to challenge practices that result in discriminatory effects and impact, it also allows the challenge of practices that result in the perpetuation of discrimination. So it is important to raise these claims, but it's still highly underutilized in housing cases. Despite of it, it's not used that often, particularly in Michigan, as a tool to combat policies that cause adverse impacts against one or more protected classes or perpetuate segregated housing patterns. And from a housing provider, mortgage provider, management company perspective, it should prompt everyone involved in any aspect of housing related activities, insurance, lending, whether they're private owners or managers, to carefully review their policies without setting up a quota, but to make sure the policies implemented do not result in adverse discriminatory effects against any protected group or result in the perpetuation of segregation. All policies must be reconsidered to make sure that there aren't discriminatory impacts or effects or perpetuation of discrimination. To proceed without undertaking that analysis, risk liability for disparate impact. Any questions? Any questions, comments? Any questions or comments? I hope this has been helpful. Ingela, Aaron, anybody? Questions, comments? Maybe you guys have some questions.
No, I thought it was a great presentation, and often a disparate impact doesn't come to light. So I think this is very informative in, helping people realize kind of what it really is and how the kind of impact it has on a protected class.
Yes, Stephanie asked ICP. That's the Supreme Court's decisions and Inclusive Communities Project, the ICP decision. That's the Supreme Court's ruling in 2015, recognizing disparate impact as a theory of liability. Disparate impact claims can be brought under the Fair Housing Act. So yeah, I'm probably using too many acronyms in that, but that's what ICP refers to. The two main things are Supreme Court's ICP decision, and the other one is HUD's 2013 disparate impact regulation. And again, this area is still up in the air because HUD has not finalized, whether it's reverting back to the 2013 regulation as written or whether we'll come up with an alternative formulation. So it's where it stands right now. It's kind of unusual. It's very unusual, especially in fair housing, to be in any area of discrimination law, to see that kind of action by an agency like HUD and court decisions, weighing out these issues. But it's certainly an exciting time, but there's certainly important claims to be brought. They can really get at the problem of racial segregation and segregated housing. I don't know, Stephanie, if that was helpful. Do I think the state of Michigan will ever adopt statewide protection of source of income? Yes, I do think they should start it at some point. We're working with Charlie Cavell, he's an Oakland County Commissioner, to have a number of municipalities adopt source of income. It's been adopted in Oak Park. I believe it's adopted in Royal Oak Township, being considered in Madison Heights. And Royal Oak may be doing it, but a number of them are starting to do it. So the idea is to start at kind of a grassroots level, city by city by city, and then build up to have statewide adoption of source of income. We are going to cover source of income. It's in an upcoming training. It's going to be in April. We will cover source of income. It's so important. So yeah, source of income. I really believe it will. I'd go so far as to say I think it's inevitable that source of income will receive protection, either at the federal level or at least it will build up to be protected at the state level. Source of income is covered under the Equal Credit Opportunity Act, but that pertains only to lending. Someone asked about housing redlining. Yeah, this, if I go back to the chart here, let's see if I still have it here. This is modern day redlining. In earlier times, redlining would consist of areas just being excluded because of ethnicity and that. This is kind of more of an indirect way, but they're still accomplishing the same effect, right? By restricting realtor services based on the listing price of homes, it ends up excluding low-income communities, which tend to be minority communities. If you look at the chart here, or the picture here, there's a gray area. I could spotlight it. Let me see if I can spotlight it right here. If you see here, oh, it's not letting me spotlight it. Maybe because it's a webinar instead of a Zoom. If you look in there, and in the background, there's a gray area, and there's a percentage, either 0 to 29% is white, not percent non-white, 0 to 29%. But the bottom one is a darker gray background, 70% to 100% non-white. And you can see the areas that are receiving no service are largely, almost exclusively, the non-minority areas. They tend to be lower income. Now, the question is, did they intend that result? Were they aware that that was resulting? Good question, right? And let me put it this way too, is, and I shared earlier, the industry groups wanted to argue HUD's 2020 disparate impact regulation, which is withdrew. It said that profit motive, it was saying that basically profit motive would be a legitimate interest for a housing provider or someone relating to housing, whether it's realtor services, sales, rental, anything housing, residential housing related. Profit motive would be a legitimate interest served by a policy. I think the case is over at that point, because here the realtor could say, well, the profit motive is, well, we want to do higher value properties because that has a higher profit for us. Correct. But the problem is you're excluding minority communities. That's the problem where it comes in. So profit motive is just too broad. And that's something on a policy standpoint, they'll have to work out. My belief or my conviction is that if someone is going to serve a community, they need to serve the entire community, not just pick out the high income areas. The Community Reinvestment Act requires banks who receive depository funds to meet the credit needs of their delineated community. And the delineated community can be a broad area. And so they examine where the bank is putting branch office locations. If a bank has a delineated community, for example, Wayne, Oakland, and Macomb counties, if they put all of their branch offices in, Northwest Wayne County, North Oakland County, North Macomb County, do you think they're meeting the credit needs of their entire delineated community? Obviously not. That's not acceptable under the it's not acceptable under the Community Reinvestment Act. It shouldn't be acceptable under other civil rights, more direct civil rights laws like fair housing, Elliott Larson, Michigan Person with Disability Civil Rights Act. They should be meeting the needs of their entire community. I hope that was helpful. I don't, but that's a good question. So again, will Michigan adopt statewide protection source of income? I certainly hope that they do. I certainly hope that they do. Redlining, yes, redlining still occurs, but this is the way modern redlining occurs. Not directly, not by redlining a certain area like they did when it came to home loans and that, but redlining in terms of conditioning services, housing related services based on the value, the price of homes. Another modern example of redlining would be appraisal practices. Just a very, very sad report. Freddie Mac examined over a recent 5-year period appraisals that were submitted into its automated appraisal database system. they examined over a 5-year period, believe it or not, 12 million appraisals. They highlighted the instances in which the appraisals came in lower than the agreed upon contract price that were reached between the buyer and the seller. They found that as you increase in the percentage of Black and Hispanic within a community, the percentage of appraisals where the appraisals come in lower than the contract price increases. It's terrible. The stunning part of it is they identified at 0.01 level of significance that disparity was driven by 31% of the appraisers in the appraisal industry. So it wasn't everybody doing it, but it was a huge percentage of certain appraisers that were driving those differences. That's another way in which redlining manifests itself. So it's more subtle. It's not as direct as it used to be. Before, it was maybe because it was just permitted. Redlining was permitted years ago, where it's outlawed today. So there's other ways around it, which is why the Supreme Court said it recognizes disparate impact as being very, very important, because there's subtle ways in which discrimination can be practiced. So that says,
Steve,
yeah.
This is Stephanie. I just wanted to thank you so much for focusing this training on this topic, because of that. Because this is really like this is the current wave in which we see such significant discrimination. And this training was just phenomenal. Thank you.
Oh, thank you. Dee has a question. Does gentrification fall under disparate impact? Yes. How would it fall under disparate impact? If there's a policy that ends up resulting in what? Showing statistically that it has excluded people based on age, or perhaps disability, since older people are more likely to have a disability. Yes, there was a case where we don't have the problem. We don't have a anti-gentrification law. We don't have a law that stops gentrification. So you got to attack it in a roundabout way. But there was a apartment complex. I forget what city it was in, but what they did was they were making it going high tempo or high scale, which many are doing. But what they did was they used to have some 5-bedroom unit apartments and 4-bedroom units apartment and 3-bedroom unit apartments. So what they did was they expanded it, like by eliminating or consolidating bedroom units. So when under the proposed plans, yes, they would have majority 1-bedroom units. There were some 2-bedroom units and only a few 3-bedroom units. The net effect of that was gentrification. But that was challenged, believe it or not, under familial status, because by the time they were done doing that process, they ended up excluding families with children. So it was a gentrification case, but it was challenged under disparate impact theory of liability as to discriminatory impact or effect against families with children. It basically excluded families with children, were largely excluded from that property. A family of any size couldn't live there. The net effect of it obviously was to raise the prices, which would result in the gentrification. But that's just a major, major problem. Yes, gentrification is occurring. There has to be something with that, Ingrid, would you want to speak to that? I think she put it. No, are you recording that I answered it?
Yes. No, I don't have any comment at this time. But what I can say though, Steve, I can see in participants how disparate impact discrimination often get overlooked, particularly by a home seeker, because when you go and they say, well, because of your criminal background, or, you have 3 people and you're only supposed to have a 2-bedroom, you have to have a 2-bedroom apartment, not a 1-bedroom apartment. I wouldn't think anything of that. So I think it's really great to know that when this kind of discrimination takes place, that to pay attention, because it does look so innocent and it looks fair on the surface, but it actually is not.
Right. Good point. And it just England knows the Detroit community, Wayne, Oakland, Macomb community very, very well. She does systemic investigations and testing. Obviously, in I don't know, well over a decade of experience doing that, and she knows the community and she knows what's occur. And so we try to be sensitive to those issues on a variety of levels. And sometimes, I mean, I'm not always faulting people. I've seen corporate actors and, that are just not aware. Some give like special benefits to people that have employment income on purchasing properties or foreclosed properties or tax sale properties, not realizing that what about people with disabilities? They don't have the employment income. There's policies where they want to recognize first responders and others like police officers, nurses, hospital workers, things like that. Well, that's good to take into consideration and maybe give a preference or a discount for people like that. But it's not something a person with a disability on SSI or someone on Social Security or SSDI or SSI could take advantage of that. So it can be very subtle, but what's happened is there's been exclusion of people, and that's how you see disparate impact violations today. They're all around us. And like I said, not trying to put anybody on the spot or get people in trouble or get people sued, but I'm just saying, putting the word out there that people need to reconsider their policies and take a look and really consider what the impact or effect of it and whether or not it perpetuates, causes, or continues segregation. And that's what the law requires, and that's what needs to be done. But I want to make sure all of us at the consumer side of it are aware of these things when they occur. And it's just amazing the kind of things that go on. I mean, I just can't. Anyways, let me, before I lose anybody. Oops, I want to say, what else would you like to know? Any future training topics? This time, please put it into the chat. Any future training, things you'd like us to cover. Next month, we're dealing with tenant protections, how to avoid being a victim of fraud, how the anti-lockout statute works, dealing with security deposits, all those things that are really, really important to tenants. But if you have other things that you would like us to cover, please let us know. I really want to know. We want to be responsive to what your needs are. Again, our services, we do housing, complaints, investigation, testing, enforcement, homeless shelters, that would be a good one. And resolution, free of charge. We do not charge anybody ever for 45 years who has made a complaint with our office. We answer housing questions. We do training and education. We do outreach. We're on Kroger baskets with advertising. We're probably going to be on SEMTA buses with advertising. We've been on billboards, anything to reach and get people more aware of fair housing. But feel free to contact us at 313-579-FAIR or fairhousingdetroit.org. And thank you for taking time today to visit with us. Stephanie, I take that seriously. As homeless shelters structured as dwellings, yes, homeless shelters do constitute dwellings under the Fair Housing Act. There's unique needs of homeless shelters. Dealing with homelessness and fair housing, homelessness general, that I think is important enough to get its own training session. Great suggestion. We need more attention on that. Good one. Any other questions?
Thank you, Steve. You have explained the theory that is not well recognized and underutilized. It's a very important tool that help fight covert discrimination. So I really appreciate it. It was an eye opener. Thank you.
Thank you. And yeah, I thought maybe I put too much material in, but unless we show a variety of situations, it doesn't make the theory clear and practical in a way that we would spot it. And again, we're looking at it from the housing standpoint. It can still apply in places of public accommodation or policies, places of public accommodation. It certainly applies in employment as well. Again, the only difference here is when it comes to housing, it has a perpetuation of segregation component as well. So it is very, very important. It is there to further the purposes and goals of the Fair Housing Act. And it's something as if we're on the professional side working in this area or working with any kind of housing related industry, we need to really be aware of it. Another data question, can a community file a class action lawsuit against the city for allowing a developer to have access to swaths of property when the community has expressed interest in purchasing the properties? It's hard to go, those are limited facts. It's hard to really analyze that. Yeah, I understand the concern. I've heard that expressed before where a city, for example, is turning over a lot of development opportunities to a particular developer or developers rather than offering that to the community at large to develop. That's a concern. That is a concern because it's taking the property out of the reach, or, I mean, I don't know. I'd have to look in that and see what kind of, what the proposed developments are. Will it have some low income housing in that? That's a good question, but that's a tough one to answer based on limited facts. All right. I'm going to stop on the recording, and if anyone wants to, well, I want to say, thank you so much for signing up, participating. Again, I'm going to put the recording or, of the webinar will be on our website as well, and it'll have the slide, so you can stop a slide and get more information that way as well. I'm going to stay on after the recording stops for people that want to talk about things, but they don't want to be recorded, kind of like an off the record type discussion as well. So thank you very much, everybody.